California evictions and COVID-19. In this video, I'm going to cover the responsibilities of landlords and tenants and the requirements for eviction due to non-payment caused by the difficulties from COVID-19.
The Real Estate Yogi.
In this video, I'll cover at-fault versus no-fault evictions, who can be evicted, when landlords can start evictions, non-payment of rent due to COVID-19, and I'll also talk about and compare AB 1482 and AB 3088. Please keep in mind that I'm not giving legal or tax advice. For that, you should definitely hire a professional. Also, before you take action as a landlord and start sending out notices, I recommend that you speak to a qualified professional to make sure what you're doing is proper and legal. So when it comes to evictions, there are two types outlined in the law: at fault or no fault. Essentially, it's asking, is it the fault of the tenant or is it not the fault of the tenant? At fault evictions include non-payment of rent, they also include a breach of the lease, nuisance, and there's a legal definition of nuisance by the state of California, which I've included a link to in the description of this video. Additionally, there are criminal activity. So criminal activity would include committing a crime on the site or an unlawful act taking place within the unit would also fall under criminal activity. Additionally, another common reason for eviction is sublease. So if the tenant subleases without specific permission in the lease to sublease the unit to somebody else. And the last one would be not moving out. So not moving out would include being given a proper and legal notice to terminate the tenancy, but the tenant refuses to vacate the premises and leave. So no fault reasons for eviction would include if the building is sold. So if the building is sold and the buyer is moving in, you need to give the tenant a 30 or 60-day notice, assuming that their lease is finished or they're on a month-to-month. Additionally, you could have a court order. So a court order would include an order to vacate, or if the property is going through major renovations, I should say. Whereas before, you could just ask the tenant to move, give them legal notice, ask them to move because you want to do major renovations. You now need a court order for that tenant to be to move the tenant out so that you can do those renovations or to keep the building vacant. Additionally, there can be instances where the owner wants to move in. So the owner wants to move in. This would be the owner themselves, their spouse or domestic partner, their child or grandchild, parent or grandparent. This would also assume that the tenant, their lease is over and they're now on a month-to-month. And again, you would need to give them proper notice, 30 or 60-day notice. The owner's brother can't move in. The owner's sister-in-law can't move in. It has to be the owner, spouse or domestic partner, child, grandchild, parent or grandparent. So the law is very specific as to under what circumstances you can have a tenant move out so that the owner can move in. AB 1482 and AB 3088. How do these two overlap? AB 1482 was a statewide California law that went into effect on January 1st, 2020, and it put two things into place. Number one, there was a rent cap. It prevented rents from being increased more than 5% plus the consumer price index. Additionally, it defined the just cause eviction requirements. AB 3088, also known as the Tenant Relief Act of 2020. This bill got rid of some of the exemptions that were established by AB 1482. For example, in 1482, single family homes, condos, townhouses, properties that were newer than 15 years old, they were all exempt from the just cause requirements. But now, thanks to AB 3088, those exemptions are lost and now fall under the just cause requirements. Non-payment of rent due to COVID-19 and evictions. So what can be done? When can a landlord evict tenants for non-payment of rent? So if the tenant hasn't paid rent before March 1st, 2020, and there are those who haven't, come October 5th, 2020, the landlord can begin the eviction process for tenants who haven't paid rent prior to March 1st, 2020. So the bill, AB 3088, was passed on August 31st of this year, and it went into effect September 1st. That's why there is a difference in how things are treated. The non-payment of rent is treated prior to August 31st and after September 1st. And we'll go into those details. So what are the responsibilities of the landlord? Well, the landlord needs to deliver to the tenant two things. They gotta deliver a proper notice, and they need to deliver a blank declaration. So the declaration is signed by the tenant under the penalty of perjury, and it's their way of telling the landlord or notifying the landlord that they're unable to pay rent due to COVID-19 related circumstances. So the tenant's responsibility is to return the notice within 15 days. And those 15 days do not include weekends or judicial holidays. So there's plenty of time for the tenant to complete and return the notice. And if the tenant is considered a high income, they would also need to return proof that their income has fallen due to COVID-19. And as far as high income in these circumstances, it's defined as making over $100,000 or 130% the median income of the county for the specific number of people. For example, if 4 people live in the unit, then you would look up what the median income for 4 people is in that county. And if they make 130% or more of that, then they're required to provide proof. Now, this is from March 1st to August 31st. The law was passed on August 31st, so from September 1st all the way to January 31st, there's slightly more to it. So the same way, a proper notice needs to be delivered by the landlord, a blank declaration. The tenant still has the 15 days to return the notice, and if they're a high income individual or family, they have to return the proof as well. However, the new law requires that 25% of the rent for each month needs to be paid. This doesn't mean that the declaration is being returned and you have to pay 25% right away. This means that for this entire 5-month period, by January 31st, 2021, the equivalent of 25% of each month's rent is due. So you can pay that throughout, or you can pay it just before the expiration. So what happens if the tenant isn't responsible for their end of the deal and does not return the notice within the 15 days allocated? If this happens, begin eviction proceedings on October 5th, 2020. Whereas in this case, if the 25% of the rent isn't paid by the due date, then the landlord can begin the eviction process on February 1st, 2021. What happens as landlord or as tenant if you've been going by the CDC moratorium and now these new laws are coming in? You're a bit confused perhaps. Well, the CDC eviction moratorium that came out a few days after the bill was passed has specific verbiage in there that says that if the local municipality or the state has laws or protections that are greater than what the CDC eviction mandate requires, then you can go by those rules instead. And Governor Newsom, has come out and said that the California law AB 3088 has greater protection. Even though this hasn't been challenged in the courts yet, it's pretty much safe to say that you can go ahead and go by the requirements of AB 3088. A few things to keep in mind. Local ordinances do take precedent over this. So for example, if you're in an area or in a city that has a moratorium on evictions saying that you cannot evict through the month of October. So until October 31st, you can't evict, even though this first scenario would give you the opportunity to begin process of eviction on October 5th, you would still need to abide by the local ordinances, which do take precedence over AB 3088. So in that example, you would need to wait until October is finished, and if that isn't extended by the local municipality, then you can go ahead and begin the process. So just keep in mind, this isn't tax advice, this isn't legal advice. Do speak to a legal professional, somebody who's familiar with AB 3088 and the eviction process under the current unique circumstances before you make any decisions or you move forward sending any notices. Armen Mardirousi with Ravens Rock Real Estate Services. I hope you found this video helpful, and if you need any assistance from us, please do not hesitate to reach out.
818-355-2850. My goodness, what are you waiting for? Pick up the phone. Give me a call.